Good morning. Today, my group members, Yu Ju, Jia Hua, Yue Qian, and I, Kesin, are going to present on the topic of duress and coercion. A contract is formed when there are offer, acceptance, consideration, and intention to create legal relation. On top of that, the courts have always been keen to preserve freedom of contract. A necessary element of these freedoms is that agreements should be reached voluntarily. A vitiating factor is a clause, provisions, or term that impairs a contract, impair or in full, or make it void or voidable. In this video, we are going to compare and contrast the respective approaches of the English and Malaysian law of contract towards duress as a vitiating factor of the contract. As per traitor, the consent of a contracting party must have been obtained by some form of pressures which the law regards as improper. At common law, such pressures could give rise to an actions for duress, which can be in the form of duress of the persons, duress of goods, or economic duress. Under Malaysian law, consent alone is not enough. The Malaysian approach to duress hints largely on the requirement of free consent, as stated in the Section 10, Subsection 1 of Contract Act 1950. An agreement is a contract only if inter alia it is made by the free consent of the parties. According to Section 13 of the Act, the parties are said to consent when they agree upon the same thing in the same sense, and referring to Sections 14 subsections A, the consent is said to be free when it is not caused by inter alia coercions. Sections 15 defines coercions as the committing or threatening to commit any act forbidden by the penal court, or the unlawful detaining or threatening to detain any property to the prejudice of any persons whatever, with the intention of causing any persons to enter into an agreement. In light of the definitions aforementioned, there are already some differences observed. The definitions provided in Section 15 of Contract Act 1950 states that the coercions must be to the prejudice of any persons. However, there is no requirement of prejudice at common law of duress in English law, as the focus being on procedural unfairness but not the substantive unfairness. Therefore, even if the innocent party do not suffer losses, the contract can still be voidable at his options, as common law of duress do not take into account the detrimental suffered by the contracting partners. It concerns only with the unfairness of the methods used in inducing the parties to enter into the contract.
Under English law, duress of person is the actual or threatened physical violence or unlawful constraint directed at a contracting party or employees or persons for whom he is responsible or his family members. It was decided in the case Barton and Armstrong that duress need not be the sole reason for entry into the contract. It was sufficient that the illegitimate means of persuasion was a reason for the plaintiff to enter into a contract. Under Malaysian law, the form of duress of the persons is found in Section 15 of Contracts Act 1950. Here, two important queries may be made with respect to this definition. Firstly, must the prohibited act of the threats thereof be directed at the plaintiff only? The wording with the intention of causing any person to enter into an agreement can only mean that the threat may be directed at any person so long as to cause the plaintiff to enter into a contract. It is not clear whether there should be any relationship between the person threatened or violated and the person induced to enter into an agreement. However, in the case Wong Afo instead of Johor, MH Whitney J commented that even if the plaintiff entered into the agreement to save his licensees who went to his place to gamble from violence, his interest in them was too remote to support a plea of duress. Similar to English law, this suggests that there must exist some relationship between the person threatened and the person induced to give rise to an interest in the person induced to be so induced. Therefore, this suggests a narrow interpretation of Section 15. Secondly, must the act be the cause of the plaintiff entering the contract? The answer is that if the coercion is employed with the intention of causing any person to enter into a contract, The agreement is voidable, irrespective of whether the duress is the sole, the main, or even only one of the reasons for another to enter into an agreement. However, to be able to bring an action for coercion under Malaysian law, it must be proved that there is an intention of causing any person to enter into an agreement. Such intention is not necessary at common law, although such a state of mind will most probably exist anyway. It is noted that Section 15 of Contracts Act 1950, the committing or threatening to commit any forbidden by the Penal Code, gives a wider definition of coercion than common law duress to the person because of the wide range of offences covered in Penal Code. For example, the offences irrelevant to violence to person. Some argue that a narrow concept of duress is observed as it does not cover tortious or other civil wrongs, nor offences outside the Penal Code. However, on closer analysis, coercion under Section 15 may not be as restricted as it appears, given the broad scope of the offence of criminal intimidation under the Penal Code. Criminal intimidation is defined in Section 503 of the Penal Code as whoever threatens another with any injury to his person, reputation, or property, or to the person or reputation of anyone in whom that person is interested, with intent to cause the person to do any act which he is not legally bound to do so, or omit to do any act which that person is legally entitled to do so, as means of avoiding the execution of such threat, commits criminal intimidation. This would suggest that even threats of breach of contract can be covered by Section 15. At English common law, threats in relation to goods are insufficient to render an agreement to make payment voidable for duress, as seen in Skate and Bell. However, in the case of Kate Astley and Reynolds, money already paid under an agreement reached due to duress of goods could be recovered. Hence, the position of duress to goods under English common law is slightly narrower compared to the definition of coercion provided under Section 15 of Contracts Act 1950. Section 15 is broader in the sense that it covers unlawful detention of property. In other words, duress to goods is expressly recognized under Malaysian law. The current position of duress to goods under English common law, however, is that a threat made in relation to good may render an agreement voidable. In the case the Siew and the Siew Tree, J stated as an obiter that if I should be compelled to sign a contract under an imminent threat of having my house burned down or a valuable picture slashed through without any threat of physical violence to anyone, I do not think that the law should uphold the agreement. Later in the dialogue, Lord Gough, approving J's obiter dictum, mentioned that since the case of the Siew and the Siew Tree, Skate and Bell is no longer good law. In short, duress of goods may now give rise to an action under both English and Malaysian law.
Economic duress usually arises when one party applies economic pressure in an illegitimate way so as to coerce the other parties to enter into a contract, or by threatening to break an existing contract unless the other party agrees to its variation or compromise. Economic duress was first recognized in England by J in the Siew and the Siew Tree, but it was held not to be voidable for duress. While it should be possible to set the contract aside where there exists coercion of the will to vitiate consent, commercial pressure was not enough. Following this line of reasoning, it was then held in the Atlantic Baron that duress could arise as much by economic as by threats of physical violence. While pressure of this nature could amount to duress, and the essence of duress is the compulsion of the will, claim was dismissed due to delay in commencing proceedings, and the absence of any protest constituted an affirmation of the contract. The mere fact that a party has agreed to a contractual variation after the other side has threatened to break the contract does not necessarily mean that the doctrine of economic duress will apply, but there have been several threatened breach of contract cases where a plea of economic duress has succeeded. An example can be seen in Atlas Express and Kafko, where there was a threat made to a small business for them to breach the rules of a contract it had entered into. In Pao An and Lau Yu Long, it was held that there was no duress as the defendants had carefully considered their position and chose to avoid litigation for commercial reasons. To determine whether a threat constitutes to duress and deciding whether there was a coercion of the will,
such that there was no true consent, 4 matters were identified by the Privy Council. 1. Did the person claiming to be coerced protest? 2. Did the person have another viable course of action? 3. Were they independently advised? And 4. After entering to the contract, did they take steps to avoid it? Per Lord Starman, the basis of the recognition for duress is that it must amount to a coercion of will which vitiates consent. It must be shown that the payment made or the contract entered into was not a voluntary act. Along with earlier duress cases, it perpetuates the theory that the doctrine avoids contracts where there is no true consent. However, there are many criticisms to the overborne will theory under English law in recent years. Professor Atiyah pointed out the inadequacy of this theory and stated that we should follow the criminal law's rejection of the overborne will, like in the case of Lynch and DPP of Northern Ireland. In Professor Atiyah's view, duress involves positively and consciously choosing between evils. This means that victims of duress submit themselves knowingly and intentionally. And in Lynch, the House of Lords recognized that duress does not make the victim's actions involuntary and that the victim's will is not overborne or destroyed, but merely deflected. Accordingly, there has been a shift in emphasis regarding the test for duress, where it must be established that there was a great pressure that gave the coerced party no choice but to act as he did. But as pressure alone is not enough to establish duress, the party coerced must show that the pressure exerted was legitimate, a threat or some form of actual violence that induced the decision to contract. In the Universe Sentinel, the requirement of vitiation of consent was replaced as the focus shifted from coercion of the will only to considering 2 other factors, which were 1. The legitimacy of the pressure applied, and 2. Lack of practical choice available to the victim. An obicta dicta from Lord Hoffman of the Privy Council in the case of R. and Attorney General for England and Wales suggests that the legitimacy of pressure must be examined from 2 aspects, which are the nature of the pressure and the nature of the demand which the pressure is applied. The Privy Council envisaged a 2-part test to legitimacy. Firstly, if a threat is unlawful, it generally amounts to duress. An example of economic duress arising from this would be the case of the Evia luck. Secondly, where the threat is lawful but is used to support a demand which is unlawful, then it may constitute to duress. Lord Hoffman observed that it is necessary to extend the category of legitimacy to catch the case of blackmail, where the threat itself is lawful but used to attain an unlawful goal. In CTN Cash and Carry Limited and Gallagher Limited, although economic duress was not established as a threat to withdraw credit facility was lawful under the terms of the agreement, Stein LJ mentioned that while it might be particularly difficult to establish duress if the defendant bona fide considered his demand valid, it was a complex and still changing branch of the law. While the traditional approach requires the proof of the pressure amounting to compulsion of will of victim, the modern approach focuses more on the legitimacy of the pressure applied. On the other hand, under Malaysian law, the main distinction of the position of economic duress is shown in the case of Perlis Plantations Berhad and Muhammad Abdullah Ang, where it was held that the English common law relating to economic coercion does not apply in Malaysia, as the Contracts Act 1950 does not provide any form of coercion other than defined in Section 15. Although some authorities recognize the doctrine of economic duress in principle recently, it was, however, not established. This can be seen in a few cases where the issue was concentrated on the question of whether the effect was to bring about coercion of the will which vitiates consent. In the case of Tech One Trading Sedan Berhad and Hydrotech Engineering Sedan Berhad, it was held that there was no coercion as it was neither penal code offence nor unlawful detention of property. Also, there was no economic duress in this case as it was merely a transaction in the ordinary course of business between parties dealing at an arm's length. In Mod Farid Subramaniam and Nazar Motor, there is no evidence of coercion of the plaintiff's will which vitiated his consent and therefore no economic duress. Thus, as mentioned by Nur Ratina Ahmad Sharif regarding the approach in Malaysian law, the concept of legitimacy of pressure as a criterion for judging its legal effect was not judicially considered, and it shows that the approach adopted by the courts is still based on a test of whether there has been free consent that is based on the freedom of contract doctrine.
The effect of duress under both English law and Malaysian law is similar, where the contract is voidable at the option of the victim. As seen in the case of Borrelin and Tin, Lord Seville stated that a contract which is entered into under duress is not valid as a matter of law. Duress renders a contract voidable rather than void because it is necessary for the innocent party to take steps to relinquish the agreement. The innocent may choose to affirm the contract, rescind the contract, or set up duress as a defense when sued on the contract. Although rights and obligations are created under the voidable contract, the victim may rescind the contract, so the contract will be set aside and the parties will be put back in their original positions before entering into the contract. Rescissions may be granted even if the victim is unable to make the precise restitution. In Malaysia, according to Section 19's Contract Act 1950, when consent to an agreement is caused by coercions, the agreement is a contract voidable at the options of the party whose consent was so caused. This is the same as the equitable remedies of rescissions available for duress in English law. Therefore, the same bars to rescissions will apply. The remedies for coercions is provided under Section 65, which states that when one party rescinds a contract, the other party is excused from further performance and rescinding party must restore any benefit received under voidable contract. However, it is made clear that the right to rescind a voidable contract may be lost unless the victim of the duress ensure that it takes actions to protest at the time or shortly thereafter. This is well demonstrated in the case of North Ocean Shipping and Hyundai Constructions, where it was held that the agreement has been affirmed and could not longer be set aside as the claimant has waited 8 months to bring the claim. However, the positions will be totally different if the duress is continuing. Applying the case Antonio and Antonio, X has suffered threatening and intimidating for 2 years until X transferred half of her shares in a company of Y. Under these circumstances, the fact that the innocent party did not act until a violent assault occurs was not considered to constitute affirmation. Damages are not available for duress, even where the contract is not rescinded. This has clearly shown that the origins of duress in the idea that there was no binding contract because of the lack of the free and true consent. If that conceptual basis for duress no longer retains its dominance, but there is a ground that why damages under duress should not be recovered on a reliable basis, as they are now for most categories of misrepresentation. Having examined the 3 forms of duress in English common law of duress and coercion in Malaysia, under Section 15 of Contracts Act 1950, it is obvious that both systems are having its pros and cons. Under Malaysian Contract Act 1950, economic duress is not included. However, it does provide statutory rights for innocent party to bring action for coercion under the Act itself. Therefore, to enhance the effectivity and the efficiency of the law of duress, both English and Malaysian law need to be refined. Several improvements can be taken into consideration. Firstly, a good idea to improve law of duress in Malaysia is to import economic duress into Section 15 of Contracts Act 1950. At a time of widespread economic hardship, many individuals and businesses feel bullied into agreements which they would rather not be party to. Apart from duress of the person and duress of the goods, there are always other reasons which may coerce one party to enter into contract or vary the terms of a contract. Unfortunately, under Contracts Act 1950 in Malaysia, economic duress has not been recognized. Section 15 of Contracts Act 1950, which defines coercion, making no mention of the principle of economic duress. This is affirmed in the case Perlis Plantations Berhad and Muhammad Abdullah Am. This can lead to the other party abusing his superior economic power and put the innocent party at disadvantage. This is illustrated by the case Teck-Guan Trading and Hydrotech Engineering 1996. The plaintiff in this case, knowing that the defendant are in need of those bars to meet its commitments to his customers and had no time to look for an alternative supplier, had threatened not to supply iron bars to the defendant unless the defendant agreed to increase the money payable to him. The defendant subsequently raised the defense of coercion to avoid paying at a higher price.
However, the court held that there was no coercion under Section 15 of Contracts Act 1950, as no offence has been committed under the penal code and refusal to supply goods at the lower rate did not amount to unlawful detention of property. As a result, the defendant has to pay the balance although he was forced to vary the terms of contract. This is not fair and just to any of the contracting party as the existing contract is deemed insecure and has not been guaranteed. In addition, this may also encourage future contracting parties to take advantage of this loophole in law. Nevertheless, although economic duress has not been exclusively mentioned in the Contracts Act 1950, authorities such as High Court appeal to recognize the doctrine of economic duress in principle. In OCBC Securities Malacca Sendirian Berhad and Co. Kihuat, Justin Locke Hopbing advocates that the courts are slowly invoking the concept of duress as defined in Section 15, or to import the concept of economic duress. This shows that, in appropriate cases, the doctrine of economic duress can be effective for a party to avoid contractual obligations which were entered into under protest, and attempt is made to rescind the contract as soon as practicable. Another advantage of adopting economic duress is that it provides restitutionary remedy entitling a party to avoid the agreement and to obtain a refund of the monies. In a nutshell, economic duress should be imported into Section 15 or Contracts Act 1950 in order to provide wider coverage of types of duress. Secondly, in order to improve law of duress in England, the better idea is to codify the common law rules of duress and provide statutory rights for contracting parties. According to Trayhill, the victim whose consent may have been obtained by way of some form of illegitimate pressure may be entitled to relief under the common law rules of duress and under equitable rules or undue influence. However, under English law, there is no statute regarding the vitiating factor of duress like Malaysian Contracts Act 1950. This caused the common law of duress to be reactive. Unlike the Parliament Acts, the courts can only change common law ex post facto. It means after the fact. They cannot change the law of their own accord. Courts can only deal with cases which are brought before them by referring to the decisions of higher courts in the hierarchy and look for those cases which share the similar material facts with the current case. The courts are not allowed to depart from the previous decisions. This makes the law to be rigid. In addition, laws and precedents may be obviously restricted and outdated and in need to be reformed. However, it is not allowed until relevant criminal charges are laid or relevant civil action is initiated. There is no opportunity for these laws and precedents to be changed. Therefore, the restrictive nature of common law will also impede the growth of contract law regarding duress. Overall, English common law of duress should be codified into statute together with other vitiating factors and mitigating factors to protect the innocent parties from being exploited by other contracting party.
In conclusion, in light of the comparisons of what mentions, it is appropriate to conclude that despite the basic similarities and common features that general meanings and the scope of the law are still differing from each other under both legal systems. As discussed, while England is moving away from overborne will theory and focus on the doctrine of illegitimate pressures, the approach toward duress taken by the Malaysian court is still based on the test of whether there has been a free consent to enter of contract. Perhaps there is still need to examine the doctrine limits of coercion under the Malaysian law of contract to provide for wider interpretation of the statutory definition in order to enhance the pre-contractual fairness.